Hi again, everybody. I'm back again at Good Job to with Chris Burks at Punchwork Law. And now we're going to talk about something a little more technical. This is probably more for employment attorneys who are listening to this episode, but also for anyone that wants to better understand what goes into case selection and process. So we're going to talk about identifying a good employment case. As most employment lawyers know, and lawyers in general know, the art of finding the right case is essential to not only helping to advance a client's interest, but also to maintaining a profitable firm. And so we're going to talk about some of the tried and true best practices around intake and case selection, and also what it takes to make a good case. Chris, any opening remarks you want to make around case selection and intake?
Yeah, thanks, Edgar. Excited to be here with you. And,
Yeah.
this is a big topic. If you're in private practice, you're an attorney, or, you're an employee that's looking to get with a law firm for a legal issue, it's a really big topic. And I think the main reason why is there's a lot of misunderstanding about what wrongful termination is.
Mhm.
So I think that's the biggest variable is there's a big misunderstanding here in this area of law about what wrongful termination is.
Yeah. Um, Tell me, Chris, why is case selection as important as case strategy for an attorney?
Yeah, absolutely. So I'll contrast employment law. So if you're representing workers or plaintiffs on the employment law side, that's different than personal injury or criminal defense. Um, in criminal defense, by contrast, generally everyone that's calling you is a family member of someone that
Right.
has a criminal issue or has a criminal issue themselves, right? They've been arrested, they need legal services. In employment law, we think of it like a funnel, but out of 100 people that call an employment law, maybe 10% of them have a legal issue,
If you're
and it,
lucky.
it you know it depends on your perspective, but it's certainly very small compared to other areas of law. And I think the biggest reason is that misunderstanding about wrongful termination. But I think there's some other factors too, like
Yeah.
HR factors and things like that. But generally speaking, most people don't know this area of law as well. And so, because of that, you could intake way too many cases way too quickly in employment law. And whatever strategy you take later is not going to matter um, if you've overindulged, so to speak. So, yeah, the intake is really the name of the game in plaintiff side employment law, and it all stems from that misunderstanding about what it means to be wrongfully terminated.
Yeah, wrongful termination is a term of art that we hear about a lot, and people um, oftentimes use it interchangeably for many different situations. Can you break down what wrongful termination is for someone that doesn't quite understand what it might mean in the legal context?
Yeah, absolutely. So, using that example of like a funnel of 100 people contacting a law firm, and let's just say for today's discussion, 10 of them, have a legal issue. It's probably less, but
Yeah,
let's say that
yeah,
10%.
yeah.
And so that remaining 90%, they think that wrongful termination means unfair termination. They think wrongful means unfair or untrue or inaccurate. Um, and so the way that we talk about wrongful termination, and particularly in right to work states, is you employee can be fired for any reason or
Mhm.
no reason at all, so long as it is not an unlawful reason. And what makes it unlawful is not whether it's untrue or unfair. What makes it unlawful is a federal law like Title VII that protects
Right.
against discrimination on the basis of race, or a state or local law. And so that 90% that calls a law firm that doesn't have a legal issue, most of them thinks wrongful means unfair, not illegal. And then a lot of them think that HR things that happen at work are legal issues when they're often just HR issues.
Yeah. No, thank you for that explanation. And I want to also cover something that you're very familiar with. You do a lot of ADA and FMLA cases. And so when thinking about uh, intake and identifying the right case for to take on potentially for representation. What are things that that attorneys or potential plaintiffs might overlook when it comes to ADA, particularly maybe around leave as a reasonable accommodation, or things like that?
Yeah, absolutely. So I think, speaking of lawyers and even, potential clients, because potential clients do the research these days. Like, or they go around and they look at the different law firms,
Yeah.
the resources like you have, and,
Mm,
they come prepared with questions. So I think this is good for everybody to know. I think there's two things. Number one, um, is the distinction between 12 weeks of FMLA leave and ADA short-term accommodations that can include leave as a portion of a reasonable
mm,
accommodation. I think that's the number one thing that, in my experience, law firms miss, and the clients or potential clients um, should be able to articulate or look into. I think, and we can talk more about that. But I think the number two thing that ties into that is, going back to that 100 people that call, only
right.
10 at 90, 10%. And, lawyers will have different opinions on that. Maybe it's less, but where people miss, in my experience, is a lot of law firms take that 10 and say, okay, maybe one of these 10 is a case that's worth going to court, or 1 in 200, or 1 in 300, whatever your particular level of selectivity is. And they will treat the EOC process as a hurdle to get to court to that outlier case that has really bad facts or really high damages. And so
Mhm,
they will start from that 100, go down to 10, go down to 1 or 1 in 2. Like, they think the answer is to dial up the selectivity on the funnel to get to the outlier in damages or liability. And
mhm,
I'm not suggesting that that is wrong, but what I'm suggesting is that that misses a lot of value for some of those clients, that 10% of clients on the front end in the process. And so you may miss the really good ADA accommodation case, because you're not attuned to that FMLA ADA distinction, and instead you're more worried about the bigger verdict, extreme outliers. So
right.
real technical stuff, but I think it's been true for me.
Yeah, yeah. So Chris, walk us through a screening framework. So, like, what would you say are best practice around screening for a good employment case?
Yeah, absolutely. So, that example of the 100 out there, right?
Yeah,
The sort of funnel or the ocean, whatever analogy, lawyers wanna use, right? Um, I think the thing about screening, and I train on this, all the time, and
yeah,
my law firm has full-time employees who are trainers, and I think, one observation just in general in any business, like, if you're not investing in internal and training and improvement,
mhm,
and you're not doing it a lot, you're not gonna do as good a job at it, if that makes sense. So
yeah,
if you're a lawyer and you think, "Hey, I know how to intake this, I've arrived, and I don't need to practice it, or I don't need to improve my process," like, that's probably not true. Like, processes can always be improved. Like, the way to get better is to do a lot of things. So that's maybe my first observation. And I think most people know that. But the
yeah,
second thing I would say on intake is, what I've found in training a lot of lawyers and a lot of staff over the years is, the people who are the best at it are the best listeners.
mhm,
And so a lot of people, may listen to that, may hear that, and they think, well, listening isn't, I mean, how do you quantify listening? How are you a good listener? I mean, that's too general an observation, maybe a critique. But I would push back on that. I would say, yeah, listening can be quantified. You can put a scale on anything, and being a good listener, really understanding, is really the key to good intake. And there's a whole lot of layers to that, but that's just at the top line for me is, um, being a good listener, training for listening, reinforcing listening, having technology and processes, that actual listen to people. I mean, it's a virtuous cycle.
yeah,
Once you really listen and understand people, they're gonna want to come to you.
yeah. No, I think for sharing that, Chris, and I would just add to the list about listening. Uh, a lot of times in employment cases, you have to craft a story, and as much as understanding the elements of the case and to fully understand what happened is important. You also want to um, think to yourself, well, what kind of story can I tell? about the situation. You know, how can I make this into a compelling plaintiff story? You know, because sometimes you might have two plaintiffs with a similar situation, but one plaintiff might seem more sympathetic than the other. For better or for worse, it's not necessarily the greatest thing, because harm was potentially done, but that stuff does matter. And Chris, do you have anything more to add to that?
Yeah, I think that's a really good frame. Stories are persuasive, and all the training I've been, all the research I've read confirms that. That's a really good point. I agree. Stories
Yep.
have beginning, middles, and end. They have main characters. They have narrative value, and that's how we understand and remember things as humans.
Yeah.
And I think tying it into the broader context, like if you've got that funnel and you're going into litigation and you're thinking of the narrative, one thing I've seen a lot of the research do recently, and a lot of the people that write on trial law and speak on trial law, what they say is, um, even within that narrative concept, really focusing on these sort of micro moments that tell that narrative. So I think a lot of lawyers sort of at the baseline that you mentioned of they get the power of narrative. I mean, in my experience,
Yeah.
they get that. But what that narrative means doesn't mean necessarily putting on evidence for the whole story equally. It doesn't mean emphasizing the whole narrative timeline equally. It means that there's a particular point here, a particular point here, a particular point here that you really kind of key in on that fills in the whole narrative.
Yeah.
And that's different than law school, I think, trains lawyers to be very detail oriented and very
Right.
comprehensive. But so if you told a first year law student on 1L, hey, the trial is going to be, it's going to be 2 years of what happened at work, but what most of the witnesses are going to be talking about and what most of the documents are just going to be 3 days of those 2 years.
Hmm.
You're in essence, you're going to have a trial about 3 days.
Right. Right.
But that I think is true because you can't have a trial about 2 years.
Right.
You
Right.
really gotta have these sort of micro moments to tie in, but, tying back to the screening and the strategies and intake, you gotta have good listeners and, don't miss the ADA. The ADA is such a strong law, and I think lawyers have shied away from it for different reasons,
Hmm.
but there's just so many people out there that are experiencing ADA issues, that there's a lot of value that lawyers can provide to those people.
Yeah. From my experience, a lot of lawyers do express some, I wouldn't say frustration, but obstacles around how do I identify a good ADA case, and how do I, take it from, all right, plaintiff tells me the story, but then I can actually make out a case out of it. So can you break down um, a screening framework for ADA cases specifically?
Yeah, absolutely. And I mean, this applies somewhat to the FMLA too, but
Yeah.
um, you know, I think one theory of lawyering, so to speak, is know the case better, know the facts better, and sort of work the process harder. And those
Yeah.
are all great pieces of advice, right? But I think what's unique about the ADA, and when you're screening, and if you're a potential client, you're watching this, you're thinking, how do I talk to a lawyer? It's more fact intensive maybe than some other areas even.
Hmm.
And so you really want to get just like the detailed narrative facts about those key moments. And so what I mean in context of the ADA is like that. Let's say, someone is calling and they're saying, look, um, I was demoted because I asked to work from home, and your intake is, you're listening to that. Well, you just want to get so deep into that ask to work from home. I'm talking about pages and pages of notes on what that particular ask was, when it was said. You just
Right.
want to go really, really deep on the facts of the ask, because one of the main reasons is defending ADA, FMLA, and also I'll throw in another word, workers' compensation. Different states have different workers' compensation
Mm-hmm.
systems or no systems at all. But if you talk to in-house employment law attorneys, they call that the triangle of death, the
Yeah.
ADA, FMLA, and workers' comp. And the reason they call it the triangle of death is because there's different requirements for each law, but it's
Right.
very, very factually specific. And so you've really got to be a great listener and taking into those facts. And it's probably more fun, Edgar, if you're an attorney. It's probably more fun to sit in on like a religious discrimination call or something like that that's just very clear. Like there's
Yeah.
one comment or 10 series of actions about religious discrimination, like, hey, that's great. I know the facts. It's
Right.
probably harder to sit through these very mundane details about ADA accommodations. Again, the ADA is just very strong. It requires the employers to engage.
Mhm.
Like that doesn't exist in other areas of the law.
Yeah. So, when thinking about ADA intakes, what are some key things that lawyers should look out for when thinking about the elements of ADA or FMLA, for that matter? And good questions to ask a plaintiff um, during an intake process.
Yeah, absolutely. So one of the things I've seen, particularly with younger lawyers, right? Lawyers aren't trained necessarily in law school about private practice. I mean, there's clinics and things like that, but
Yeah.
I've trained a lot of younger lawyers over the years, and um, one of the things I see is they ask legal questions. They ask for legal conclusions. And
Mm,
I'm not saying that you don't want to arrive at that legal conclusion. You certainly want to have an intake process that does, but you can't ask, for example, if I say, Edgar, what date did you suffer an adverse employment action? Because you and I know that adverse employment action is a term of art.
right.
It means certain things and doesn't mean others, but the client on the phone doesn't know what that means legally.
Right.
And so if you ask them, if you have a checkbox in your process, date of adverse employment action, they're not going to say that. I mean, they're going to give you an answer, but it might be the wrong answer
Right.
because
Right.
there's this Muldrow case that came out, this Supreme Court case that has broadened the definition a little bit of an adverse employment action, and so it could be a suspension without pay with a change in responsibilities. So you want to ask better questions. You want to ask, when were you suspended? When were you demoted? Were
Right.
your responsibilities taken away? And then you can arrive at the legal conclusion. But that's where I see lawyers mess up. Another thing I see lawyers messed up is um, they don't want to sift through as much of the emotional weight of the situation. And I'll contrast this with other areas of law, like family law, for instance.
Mhm.
Lawyers to some degree self-select into the area of law that they're interested in or they're similar to. I mean, not always, but and so people, in my experience, that work in family law are more interested in what's going on in a family law case. They like the dramatic back and forth to some extent, right?
Right.
Or maybe they don't like it. I, the point is, a lot of employment lawyers, in my experience, are saying, I don't want to do family law. I don't
Yeah.
want to engage in the back and forth and messiness of these feelings and these emotions. And my point back to them is, you're doing that. It's just in a different context.
Right. Right.
You're a person's relationship to work and how they feel about it is often just as much an emotionally charged battlefield as family law. Not always,
Right.
but
Right. No.
a loss of a job is, there's some research that say it can be the same as like a death of a family member in terms of the emotional impact. So
Yeah.
you cannot shy away from getting into the emotional impact with people. And if you actually listen to them and you dive into the emotional impact, you're going to get out of it a lot better set of facts and a lot better story about what actually happened.
That's a very good point. With employment cases, they can be very emotionally fraught for people. And a lot of times, if you're talking about someone who's been in a career or industry for multiple years, and that is, not only the way they support their families, but it's how they identify themselves. It was almost as if a job loss is taking away someone's identity. And we do have to handle that with care.
Yeah, absolutely. And if you're an employee, I mean, don't give up hope. I mean,
Yeah.
like I said, there's a lot of misunderstanding about wrongful termination, but do your research, reach out. There's a lot of resources out there. And even for, say that 90% that it doesn't need legal services, there's a lot of value out there in educating yourself and protecting yourself. And I would say, going back on the intake point, um, it I think that employment lawyers just need to acknowledge we are family lawyers just in a different context at work. And if you embrace that, and you embrace, because tying that into trial strategy or strategy later, like, humans aren't rational robots, right? Like, we're not, like, I think that employment law there may be a tendency to, like, perceive it more like bankruptcy where there's just a
Hmm.
lot of regulations, and there are a lot of regulations in employment law. I mean, there's case law, constitutional law, statutes, regulations. I mean, but there aren't as many as in bankruptcy. The facts, um, matter, generally speaking, more in employment law because there's less regulations as compared to bankruptcy, but those facts aren't, like, neutral,
Right.
things. They're very emotional interactions between people, and if you don't, I guess I'll say it this way, it is more important to understand those and to advocate for those than it is for, like, some mundane thing, like trying to prove that, you know, Bob went and got coffee at 10 a.m. That, like, the jury's not gonna remember when Bob went to get coffee. They're gonna remember that Bob went back to his desk and closed his door and started crying and called his wife, and she didn't answer, and then he didn't tell his wife because he was too embarrassed. So, like, they're gonna remember
Yeah.
that, and
Yeah.
to get that, Bob is not gonna tell you that when he first calls you. He's not gonna tell you, "Hey, what happened? I got fired because of my age. I couldn't even tell my wife about it, and I was crying my minor." He's That's not the first thing out of his mouth. But if you don't get that out of him, if you don't understand him and listen to him, you're not really giving him the value and the service and the help that he needs.
Yeah. Any final takeaways, Chris, on intakes, identifying a good case, and being putting someone in a position to advocate best for a potential client?
Yeah, absolutely. Some big picture thoughts. I mean, 10 lawyers probably have 100 opinions, right? I mean, that's lawyers, but I really appreciate the work of your organization, Edgar.
Yeah.
And I would
Thank
say,
you.
just big picture, if you're in private practice, um, don't treat employment law as that much different than other practices. And so what I mean by that is embrace from family law, embrace the emotional messiness from personal injury, and embrace the fact that there is pre-litigation processes. Like in personal injury, they send demand letters.
Hmm.
Embrace those pre-litigation processes just like personal injury does in employment law. Take the trial lessons from personal injury from other areas of law, incorporate that into family law. So family law, uh, and employment law, of course, is different, but it's not that different. And really, private practice, it is law, it is different, but just like any business, you've got to listen to people to really be doing a good job. And so
Yeah.
that's probably harder for lawyers that like to talk to listen. I'm here talking to you, Edgar, but that's been my experience. Is just let's stop treating employment law like it's a unicorn. It's got a lot of commonalities with personal injury and family law and criminal defense, and let's treat people like treat people. Let's listen to them, and
Yeah.
let's not hang on. Let's not turn everybody down for that
Hmm.
one out of a million big case. Let's help a couple people in the ESC process too that may have some ADA issues.
Yeah. Well, Chris, thank you so much for this. I really appreciate the level of detail and care you brought to this topic, and just for everyone listening, Workplace Fairness has different content on how to identify for yourself what a good case might look like in all types of employment law situations, particularly discrimination or ADA or FMLA cases. And also, Punchwork Law has plenty of resources as well on their website. And also, Chris is a tremendous resource as well. So thank you all. And Chris, any other resources that you want to promote or share?
Yeah, thanks a lot for doing this, Edgar. Again, your website is an awesome resource. I would say the eeoc.gov is
Yeah.
a decent resource, an official government source, authoritative. But I think if you're experiencing a workplace issue, there's so many people that want to help you. It feels lonely, it feels isolating, it feels
Yeah.
frustrating a lot of times. But there's a lot of good people out there like Edgar that do the work to try to help.
Thank you. But thanks everyone, and take care.